If you go to the docket, you can see everybody's business. You can look up all of the pleadings, read it like it's a gossip column. So with mediation, this is typically the first level of dispute resolution. Generally, it is required by, sometimes, most often, either the judge will require it before they ever hear it at a trial, or some contracts now have clauses that say, let's go to mediation before we even take this to court, okay? And then some contracts also say that we're choosing to go to arbitration as opposed to taking it to the state courts. Why do we think that we're choosing arbitration over the state court?
Avoid the fees, court.
Yes. Drama, fees, it's private, right? So if you go to the docket, you can see everybody's business. You can look up all of the pleadings, read it like it's a gossip column. It's very public. And then we're including contracts as attachments. And now the public, the general public, knows what your contracts look like. Do you want that? Absolutely not. And it's costly and time consuming. And we're dealing with a judge that we don't know their mindset. We don't know what their beliefs are. So you get to choose who's going to be the arbitrator if you do arbitration. Then also there's no jury. So some contracts will say we're going to go to court, we'll have trial, and it's going to be a jury trial. Do we know those people? So why do we want to put your business in their hands? That's another issue that we don't want to put ourselves in. The mediator has to be impartial. They cannot take sides. They can tell you what the worst case and best case scenario can be. They can't give you legal advice, and they cannot force a settlement. What happens if they force a settlement? They could also lose their license to be a mediator, right? And they could be either sanctioned by the Florida bar or also suspended. So absolutely. If you find that you're in mediation and the mediator is just being aggressive, then you can just walk away. You're not required to enter into the settlement because you feel that the mediator is being pushy. If you find that they are imposing a settlement, you know that they are acting in bad faith or unprofessional, and you get to just walk away. And what that means is you've reached an impasse. No party agrees to the terms of the settlement. Okay. With arbitration, the American Arbitration Association construction industry has mediation rules, and they also have clauses on their website, example clauses. So if you want to take a look at those, you should go to adr.org. So you can be referred to mediation by stipulation or by a judge. So as I said, if you had a contract that says that we are to go to mediation before we take this to any type of governing body, so that's the arbitrator or the judge, you want to make sure that both parties know that this is the next step, and you can stipulate by agreement, or the judge will order you to go to mediation. As I said, if you want to take it to court, the judge is always going to order mediation first. Have we ever been to small claims court before? No? Yes? Yeah? Okay. So in small claims court, opposing party files a complaint, and if you're defending like a credit card debt, you go and tell your answer and tell the judge, do you agree to the debt or you don't agree to the debt? And if you don't agree to the debt, then the judge will, and they have a pool of mediators just off to the side. And as you say no, they say, okay, well, here's the mediator. You all go and mediate, or you can schedule a mediation at a later date. You have a dispute. Even if it's a credit card debt, you have to go to mediation. Mediation must be initiated within 60 days of starting a lawsuit, which is why the judges have the mediators off to the side in this instance. So a party may move within 15 days after order of referral to dispense with mediation or arbitration if the issue to be considered has been previously mediated. So sometimes the court will say, you guys, you need to go back to mediation. And you could say, no, Judge, we've already talked about this issue. It was an impasse. We need you to hear this, right? And it happens more often than not, especially in family court. The issues present a question of law only. So that means, were they negligent or not? We're not talking about damages. We want to know if this party is at fault or if they breached the contract. A mediator cannot make that determination. The court can. If you felt that you are being pushed to settle in mediation, that goes back to having a settlement agreement, for instance, and the mediator says you must sign this, then you feel like you were pushed into this agreement. That's a great question. Who assigns the mediator? The court can assign the mediator. So in Hillsborough County, they have a mediation and diversion program. And that is more of a low-cost service. And you get assigned to a random mediator, and you only get 2 hours. And it's based on the party's income. So I believe if you make over $50,000 combined, both parties combined, each party has to pay close to $200 apiece. That's based on income. One mediator, yes. Because the mediator is going to sit in, listen to both sides of the story, maybe put the other party in another room and then go back and forth and have a conversation with them. Or you have the conversation inside of the room together and you can come up with an agreement at that point. The alternative, if you hire a mediator that is not within the court system and they're a private mediator, the cost goes up. So some mediators charge as low as $200 an hour. Yeah, that's a lot of money. So mediation is generally not just an hour. Mediation can go from 2 to 9 hours or a couple of days, depending on the dispute and depending on how many issues that we have to discuss, right? So you may have multiple days of mediation.